Well, greetings and salutations, test takers. This is the Series 7 Guru, and I'm coming to you from my studio here in fabulous Las Vegas with a final episode of our Series 7 podcast series. 10 episodes. This is the final one on new issues or the primary market. We don't always do them live, but tonight I am doing it live. If you are joining us, you have any questions about this content or any other FINRA or NASA exam content, at the end of this, about 30 minutes, I'd be more than happy to take care of those questions. If you're watching the recorded version, well, obviously, we won't be here at the end of the episode. All right. So we've been doing it in reverse order, this podcast series of the waiting of the exam. So if you go to the FINRA website and you print out the FINRA content outline for Series 7, it has 4 functions. And we've been doing the functions in order of waiting. So we did function 3 in this podcast series. Then we did function 4. Then we did function 2. And now we're doing function 1, which is 9 questions here on the new issue or primary market. Primary issue is where the issuer receives the proceeds. All those transactions together are called the primary market. You know, in 33 and 34 were companion pieces of legislation. And all that legislation was called the New Deal. You know, and prior to 33, I'd say, trust me, you'll love it. You know, President Roosevelt, when he passed all that New Deal legislation, 33 is known as the Paper Prospectus Act. Sometimes you can get questions right by covering up the screen. Are they asking me about paper prospectuses? 33. Are they asking about people and places? 34. You know, every once in a while, somebody says, well, gee, Dean, how did they, come up with 33 when there was no SEC? And Congress knew when they passed 33, they were going to be passing 34. And President Roosevelt said, you guys will thank me later, but we're going to change the securities industry from let the buyer beware to let the seller beware. We, the ones selling the security, particularly in the primary market, have to make sure we do it correctly. And so under 33, if we're going to sell brand new securities to the public, we have to make a registration statement. Hence the term registered securities. Registered securities are securities that have gone through this process. Unregistered securities are securities that have not gone through this process. Once we make a registration statement saying that we're going to sell brand new securities to the public, we enter into the cooling off period or the quiet time. Now, if we didn't have the cooling off period or quiet time, I'd be calling you every day going, hey, you know what IPO stands for, don't you? Instant profit opportunity. This thing is going to be hot. Now, what I'm supposed to say is I'm not allowed to comment on the prospects of the issue. What I can do is send you a preliminary prospectus known as a red herring. Based on that preliminary prospectus, I can accept indications of interest, which are non-binding on all parties, known as IOIs. And I'm not allowed to advertise, but I am allowed to place a tombstone. A tombstone says this is neither an offer to sell nor a solicitation to buy the following security. An offering is made only by a copy of the prospectus. Read it carefully. Do not send money. We should know the preliminary prospectus has pretty much everything you need except the final offering price, which is important, right? It would typically have a window of pricing. So whenever you have 3 of the thing here, preliminary prospectus, IOIs, tombstones, you should be prepared for the accept format. All the following would be acceptable during the cooling off period, except. Another thing we like to do is torment you on pieces of paper, documents. And the underwriting agreement is between the issuer and the syndicate. The issuer and the syndicate. For example, people don't recall this, but the IPO, the initial public offering of Facebook at 38, was a wobbly deal. It wasn't, hot. In this case, IPO stands for it's probably overpriced. I'm joking. Initial public offering. When they were asking Zuckerberg how he felt about 38 and it getting wobbly, he said, well, we understand firm commitment underwriting that 38, that's, the syndicate's problem. That's their stock at 38. See, you wouldn't want to be. His understanding is very good. Now, the underwriting agreement is the contract between that syndicate and Facebook that, in this case, firm commitment says that they're going to get $38 a share. And syndicate members, particularly in this case, are going to be at risk for unsold securities. Now, if I'm one of those syndicate members and I have some stock and I want some help selling it, I can build a selling group. Maybe I'm UBS and I call Fidelity. I say, hey, Fidelity, you have lots of retail customers I think might be interested in this IPO. Would you like to join my selling group? So selling group members are signing up under syndicate members. Selling group members are not liable for unsold securities. They're not members of the syndicate. The selling agreement would be between the selling group member and the syndicate member, in this case, UBS and Fidelity. Now, based on the spread is the difference between what the issuer receives and the public pays. And there are three components to the spread. There's the manager's fee. On my Facebook example, the manager was Morgan Stanley. So it doesn't matter who sells the stock, Morgan Stanley gets their management fee for running the deal, keeping the books. They get that. And then the stock they sell, they're also going to get the underwriting fee. They want the stock they sell through their own distribution network. And assuming they don't build a selling group, they'll get a selling concession. In this example, UBS isn't getting the management fee, but they will get the underwriter's fee, and they'll get the selling concession on the stock they sell, and the stock they give up to Fidelity would get that. Typically, the smallest individual component of that spread is going to be the management fee. And typically, the largest individual component of the spread is going to be the selling concession. Now, in munis, the phrasing is a little different, and I'll bring that up. In underwritings of munis, it's not called the underwriter's fee, it's called the additional takedown. And then the additional takedown of the selling concession is called the total takedown. But please note, RTFQ, that means read the full question. If I ask you in a municipal syndicate about components of the spread, the total takedown is not an individual component. So if I say largest component, be total takedown, individual component, once again, be selling concession. Now, we don't tell you how we break up that money because it would just confuse people. But we do show you on the front page of a prospectus how much money we're raising in total. Like, I'll just make up one. Let's say we're selling 10 million shares at 10. So we're going to raise 100 million. Let's say our spread is 8%. So the issuer is going to get 92 million. We're going to show you that to you on the front page of the prospectus. We're also going to show that to you on a per share basis. We're going to show you the 10 and the 80 cents and the 920. And then we're not going to share with you how we split up the money because that depends on who you are and how many shares you sold and all that kind of stuff. Now, not only do we have to register the securities under 33, we're further going to have to register them in any state we plan on selling them. Those are called blue sky laws. Blue sky laws are laws that are unique to a particular state. There's not a coincidence why every time you leave a state, there's a sign leaving state A, entering state B. And I have two levels of protection as a retail investor. I have the SEC who protects me federally, and then I have my state administrator who protects me on a state basis. I'm coming to you from Nevada. And so, the state administrator of Nevada protects retail investors in Nevada. And if you're going to sell this security in Nevada, you're going to have to register it as well with the state through what we call coordination. Now, I would imagine that a lot of you, the last leg of your testing journey is going to be a 66. And I warn you, about half of that exam deals with, state stuff. That's seven, not so much, right? Whether it's gun laws, liquor laws, securities laws, we're going to have to register that. Now, when they passed 33, the U.S. government said your own government would not rip you off. And so the U.S. government is an exemptive for securities, meaning I don't have to register. The U.S. government doesn't have to register T-bonds or T-notes or T-bills or Ginnie Maes or Fannie Maes or Freddie Macs, any of that stuff. So the state administrator, SEC, says, hey, Dean, did you sell an unregistered security? I say, yes, but it came from an exempt issuer. It was a, Treasury security or agency of the U.S. Treasury. Well, then states say, well, if you don't have to, we don't have to. And so municipal securities are also exempt from making registration statements. Now, I have a whole entire lecture on underwriting muni bonds. No surprise that I highly recommend. But muni bonds are a little different in the corporate than corporate underwritings. So one thing, if we're going to do a competitive underwriting, so this is where the issuer, the state, the city, the county says, attention, investment bankers, we're looking to raise some money on a competitive basis. I think a good analogy would be your mortgage, right? If you are going to get a mortgage, you can go into your financial institution and say, hey, I'd like to negotiate. I want you to give me the good deal. And if I find out it's not a good deal, you're jeopardizing our entire relationship. Or I say, don't kid yourself. I'm going to award the mortgage to the one who provides me with the lowest net interest cost on the mortgage. Right? Same with kind of underwriting here. So if it's going to be a competitive municipal bond underwriting, the issuer is going to file a notice of sale or publish a notice of sale in the bond buyer. So we should know as test takers that notice of sale means it's a competitive underwriting. Because if it wasn't a competitive underwriting, there would be no need to publish the notice of sale because we would sit down and negotiate. You should further know that that notice of sale is going to be filed in the bond buyer. The bond buyer is a now electronic, but newspaper widely read in the municipal market. And based on that notice of sale, various syndicates are going to be formed. And again, we mean that's going to be a competitive transaction. I have a video that says all tips, tricks, and memory aids for Series 7. And every once in a while, I get somebody who says, hey, Dean, how come you don't have pro golfers don't miss in there? You don't have pretty girls date more, pretty girls drive Mercedes. I said, well, I don't have it in there because nobody in years has told me they've actually seen order priority in a competitive underwriting. But if it was, on your test, I don't think it will. That's a memory aid device for pre-sale orders. So I'm Bank of America. I get a call from Franklin Templeton, and they say, hey, Dean, are you forming a syndicate? I am. They say, if you win, we'd like $20 million worth of the bonds. Wonderful. I shouldn't feel special because they're going to, call every syndicate around town because they want the bonds. We win the underwriting, and now I get another call, American Funds, and they say, hey, Dean, we want $10 million worth. I say, who would you like to designate? They say, well, Dean, if I designate you, Bank of America, then I, piss off JP Morgan. I like them. I see they're in the syndicate and UBS. Just leave my order a group or undesignated order. And split the largesse, split this, the fees with everybody in the syndicate. Pro golfers don't miss designated orders. This is where Fidelity calls and says, Dean, we want $15 million, designate Raymond James. If you're Raymond James, you might want to call and say, hey, thank you very much. So, and then member orders, the one we want for our own inventory, our own UITs, or our mutual funds comes last. And so that's what we call order priority. Again, pre-sale group, designated member, pro golfers don't miss, pretty girls date more, guys, whatever sexual preference may be. Again, I don't cover it in any of my lectures because nobody has told me they've seen it in a long, long time. We talked about syndicate formation, and we said just like stocks, there's going to be components of the spread. And in muni underwritings, the components of the spread are going to be the manager's management fee, the additional takedown, and the total takedown. And again, we have different types of syndicate as it relates to munis. We have Eastern syndicates and Western syndicates. Sometimes we refer to Western as a divided syndicate. What goes down stays down. So if it's like $100 million deal and it's a Western syndicate and you're a syndicate member, you're a firm, and you say, we'll take down 20 million. What goes down stays down. Your liability is 20 million. So if you sell 12, 8 goes into inventory. Whatever you say you're going to do. I had some ladies that were in class from Artemis Capital, a very fancy lady owned and controlled muni firm. And they said they think of it as a family dinner. In a Western family dinner, you just got to eat your own meal. Now, if it's an Eastern or undivided syndicate, it's not important that you told me 20 million. What's important is that that's 20% of the deal, and that's going to be your liability. And again, I give you all kinds of examples of that in the lecture on underwriting munis. These are podcast episodes, and so we're trying to keep them in at 30 minutes. But if you need to review that, I have referred you to the appropriate spot for that. Another thing that we do in munis is advance refunding. So, if I work in public finance, corporate finance are men and women who raise money for corporations. Public finance are men and women who raise money for municipalities. And if I'm involved in that business, public finance, I might do some homework and call the municipal issuer and say, hey, you have those 5% bonds outstanding, and brand new bonds can be issued at 2. And you say, well, Dean, if you did your homework, you would see that they haven't passed their call protection period. So I can't call those bonds even if I wanted to. I said, well, listen, what I think we should do is sell some new bonds today at 2%, take the proceeds, put it in an escrow account. I'll help you invest that. And then when those 5% bonds pass their call protection period, you can call them. If you get a question about advance refunded or pre-refunded, the point here is the bonds are going to mature. So I call you and you own the 5% bonds. You're my client. I say, hey, those 5% bonds? You go, Dean, I love them. They haven't passed their call protection period. They can't call them even if they wanted to. Brand new bonds only pay 2. The ones I'm holding pay 5. I said, well, they've advance refunded you. Great. They owe me the money. They got the money. They're AAA. Are they defeased? I say they are defeased. That means they get to remove them from the debt statement because defeased means dead. That debt is debt. We have a matching asset. He said, why are you bothering me? Well, I'm bothering you because you're not going to get yield to maturity. So that would be the point. Now, I told you that muni bonds are exempt from 33. And so that means we're not going to be using prospectuses when selling muni bonds. We're going to be using official statements, and they serve the same purpose. Don't tell me it's a prospectus, but it's a prospectus-like document to help you make an informed decision. All right, so, one of the things that we're held accountable for on the test is exempt transactions, not exempt securities. That too is testable. I gave you 2 already. U.S. government, municipal issuers, and U.S. government issuers are exempt from 33, meaning they don't have to make registration statements. And that's simply a list of various securities. And then there are safe harbors. Safe harbor is a legal term. So I go to my attorney and I say, hey, listen, I want to sell securities, but I don't want to register them. What are safe harbors available to me under 33? Is there a way for me to sell unregistered securities without running afoul of 33? Those are called exempt transactions, safe harbors. One safe harbor is available to what are called qualified institutional buyers of securities, QIBs. A qualified institutional buyer of a security, that's, again, somebody who's managing, has assets under management of 100 million or more, is allowed to buy unregistered foreign and domestic securities, right? So we can sell unregistered foreign securities to QIBs in the U.S. is the point. And that is one exemption that is available under 33, a safe harbor. Another safe harbor available under 33 is Reg A. Reg A is not Bob Marley music. So again, the SEC says, Dean, are you selling unregistered securities? I say, I am. They said, well, Gene, what safe harbor or exempt transaction are you using to do this? I said, I'm using Reg A. Reg A, Tier 1, I can go up to 20 million, and that's the test question. Tier 2, I can go up to 75 million, and that is the test question. So these are safe harbors. I'm selling this to the public. Another one that we're held accountable for, this one's a little tricky, Rule 147. If you are coming back for your Series 66, this one is exempt under 33 that we're discussing right now, but not exempt under the Uniform Securities Act. So I still have to register the security with the state. So it's not registered under 33, but it is registered with the state. So let's talk about what I have to do for this safe harbor. We have what's called, very testable, the 80% test. Under Rule 147, an intrastate offering of securities, the issuer has to have 80% of their business and assets within the state. We can only sell it to residents of the state. And after 6 months, a resident can sell it to a non-resident. As I said, I still going to have to register this through qualification with the state administrator. So what do I need to do to sell this to residents of your state? So while I'm exempt on 33, I'm not exempt under the Uniform Securities Act. They say, Dean, did you sell brand new securities to the public without making a registration statement? I said, I did sell brand new securities, but I didn't sell them to the public. This was a private offering. It was an investment by invitation only. And I only invited accredited investors. And very testable, no accredited investors. 1, 2, 3, right? $1 million net worth exclusive of primary residence. $200,000 in annual income with the expectation $200,000 this year. Married and filing jointly, 300 grand in annual income for the last 2 years. Expectation of this year, 1, 2, 3, right? If you are an accredited investor, then I can forward to you the invitation, the private placement memorandum. Good news for you. When you pass your Series 7 and you're in good standing, you too will be considered an accredited investor and therefore can participate in a Reg D private placement. Now, under Regulation D, this private offering we're discussing, there's two versions of this. There is 506B and there is 506C. What are the distinctions between the two? With 506B, I can have an unlimited number of investors that are institutional and accredited. But I can only have up to 35 non-accredited investors. I am allowed to have up to 35 non-accredited, but I can't solicit. I can't advertise. Now, if I kick those 35 people to the curb, so, when I was a practitioner, I said, listen, we don't want to do 506B because I plan on promoting this pretty hard on your behalf, issuers. So let's go with 506C. With 506C, once again, I can have an unlimited number of accredited investors and institutional investors, but I can't have anybody who's not accredited. But I can solicit, I can advertise, which is kind of cool, right? Now, the other thing we need to make sure people understand is that when they are participating in a private offering, a private placement, the securities that they're getting are unregistered, right? And these securities in this Reg D private placement have never been registered. For example, SpaceX is a privately held business, and they've raised billions of dollars through Reg D. And so all this money that has been raised has been coming from institutional investors and accredited investors. It's a 506C Reg D, meaning, again, we don't have 35 non-accredited investors buying this security. Okay, so I think that's a nice little overview. I told you we're trying to take these, bring them in about 30 minutes. I think that's a nice little episode. I'll pin in the video description and in the comments, I'll pin the full-blown videos on underwriting corporate securities and underwriting municipal bonds. Remember, inch by inch, your Series 7 is a cinch, yard by yard, your Series